Hello, everybody, and welcome to the Cathleen Scott podcast. I'm really excited to be here today. We're here with a work injury expert, attorney, a good friend as well. It's Ara Gechijian. He's a workplace expert. He is a good friend and a workplace attorney. So we're going to be asking him all things about workers' comp and his experience and learn a few things and interesting things in the lives of busy lawyers. So thank you for coming, Ara. Welcome to the podcast.
Thank you for having me. Super excited to be here.
So, I get a lot of calls in my firm. I do labor and employment, but we don't do the injury side of things. And so people always think those things are the same, but they're very different. So I want to ask you some questions. If somebody's out there and they think they might have been injured at work or they suffered an injury at work, like what's the go-to checklist? What should they do?
Well, if you're injured at work, first thing is, are you an employee of that place that you're considering suing from having been injured at? There's contractors or subcontractors. You may not be an employee. You may be an independent contractor. Even with that, sometimes a lot of employers have employees sign an agreement that...
You mean they have them misrepresent their employee status?
Shocker. I know.
We never see that, right?
Thanks for not falling off your chair. I know, it's weird. And they make them acknowledge that they are an independent contractor when they're actually not. Because when the employer controls so much of the duties that they're performing, they're actually deemed an employee under the statute.
So employees out there listening, don't rely on the document you signed. If it quacks, it's a duck. And so there's an analysis, right, to whether or not they are, in fact, an employee.
100%.
Okay. And the document, just like it does in our world, doesn't really mean very much. What they do matters.
Nope.
Yeah.
It's what the document means in the eyes of the court, which is facilitated and assisted by usually legal counsel, because there's a lot of nuances in Florida when it comes to workman's comp, exceptions out there, exemptions out there. So it's hard to navigate, but yeah.
So step one is, who is the employer?
Who's the employer?
But from the employee's perspective, even if they're not sure, who do they report to? Like who's in that situation where like maybe you signed something thinking you're a contractor, but maybe in actuality you are an employee, who should they report the injury to?
Whoever their boss or supervisor is.
Okay.
Who's ever dictating their duties, job obligations, things to do.
Got it.
The next in line in command.
Okay. I've heard employers tell me, "Oh, I'm a small employer. I don't need workers' comp coverage." How does that factor in? Is there a number of employees requirement? How does that work?
Yeah, 4.
Okay.
4 or more, you got to have work comp insurance.
And what about for like kind of more, I guess, more dangerous jobs, like in the construction industry, for example? Like, do they need insurance even if they don't have 4 or more employees?
No, they're good to go,
Okay.
but they usually will be a sub to a GC.
Okay.
And they'll have fewer employees because there's a limited job for them to do. The GC has other subs to do
Okay.
a lion's share of other stuff, so they parse it out.
All right, good stuff. So what's step 2? We first got to figure out who they're employed by, which seems like it's obvious, but it's not.
Yep. Correct.
Correct. And in our world, we can have multiple employers too, right? Like
Sure.
sometimes we have a situation where an employer uses like a payroll company and they're like a leasing company. But sometimes that's a good thing for workers, right? Because do they get coverage under that as well, right?
Yes.
Yeah.
Yes.
So that's good stuff. Okay, what's next?
So the next step is, were you injured within the course and scope of your employment? You got to be doing something work-related. You can't be out fluffing off. You can't be on break.
Okay.
Again, there's exceptions, but were you performing some job function for the employer?
So, and that's not always so clear, right? I mean, obviously, if you're climbing a ladder and you're at work and you fall off the ladder, that seems pretty obvious. That's during the working hours, right?
Sure.
But then there's those, like, as there is with everything legal, there's the quote unquote gray area, right? So, what about if you're driving home from work and you get into a fender bender?
Sure. With anything legal, there's always gray areas, or else we wouldn't have a job.
That's right.
So, going and coming, where you're going to work and coming home from work generally is the going and coming rule. It's not covered.
Okay.
But there are exceptions with that. If your boss asks you to pick up a box of nails on the way to a job, that's a special errand. That may very well be compensable in the course and scope of employment.
Okay.
If you punch out, heading home, generally not covered under work comp because it's not in the course and scope of the employment.
Okay, so generally speaking, and obviously there's exceptions, but if you're getting paid and it's compensable, that's a good rule of thumb, it sounds like.
Absolutely.
I've had some clients recently. One woman was really sick. She had like a lung injury, lung infection, and she felt like it's because everybody around her at work was vaping all day long.
Oh, wow.
So could that be workers' comp?
So the statute requires you to have an injury.
Okay.
So an injury could be as little as a touching.
Got it.
Heart attack cases can be compensable if there's something extraordinary that happened, fireworks gone off, something crazy to have sparked that But what you're talking about would go to more of an exposure case.
Okay.
And the legislature has really heightened the standard in Florida to prove, carry a burden to show an exposure is related.
Good old Florida legislature.
Florida ziplocked that one.
Yeah.
It's really hard to prove. I had a...
It's like mold exposure or something I feel like is popular right now, the vaping. But I had a client who was injured by swimming, and they were like, well, swimming was part of her job, and they thought maybe it was an ear infection, but then, or maybe it's just like she was getting vertigo, so maybe that's just something she has, and maybe that is or isn't workers' comp. So it seems like there's a lot to know there.
The exposure cases are really hard to prove.
Okay.
The cost for experts in those types of cases are astronomical. With a mold case, you'd have to have an expert come in and measure parts per million mold there.
Okay.
Rule out any other exposure in the person's life to mold, which would be really hard to do.
Wow. Okay.
Yeah, it's an arduous process, and a lot of claimant lawyers are not taking any type of mold or exposure cases anymore.
Okay. But if a claimant's out there, potential claimant's out there, we want to encourage them to go to the work comp lawyer, give you a call, then make that decision. So they're not just like at home deciding for themselves that they don't or they do have a claim, right?
We're not lawyers, we're advisors first.
Okay.
And we give advice.
Yes.
And I always encourage people, just give me a call, pick my brain.
Whether clients take it or not is entirely up to them.
100% up to them.
Yeah.
But usually they're appreciative of the advice, and some call back and sign up with me, and some just take the advice and move on, and that's okay. They'll always remember that I gave them the advice. But to navigate a legal case on your own, I don't care what area of your law you're doing, it's tough for the layperson. So.
It is. And I'm a big believer in like leveling the playing field. Like people need access to lawyers. It can't just be for those who can afford it, right? So
100%.
like, yeah. And I feel like most of your cases are taken like on what we call a contingency fee, right?
All my cases are contingent based.
So it doesn't cost anything for a client to call and find out their rights.
Nope.
That's awesome. That's amazing.
Yeah.
So let's talk about you personally.
Okay.
Been practicing since 1999.
Long time.
Same as me. So I learned that getting ready for our podcast. We have that in common. We've been both doing this over 2.5 decades.
Love
Who's
that.
Counting.
Yeah, I love that.
So why injury law?
It found me. I didn't find it.
Okay.
I graduated law school, was doing some PI work for a plaintiff firm, and I saw a job posting for a work comp defense lawyer. Called up, interviewed, loved the firm, loved the guys, did it for 20 years. I was a partner in that firm, and then I flipped sides. Now I do injured workers. So it's a unique area. Wasn't looking for it. Just
yeah. Isn't that funny? I respect that. And I myself try to do a little of both sides as well, employer-employee sided, because I feel like it makes you a better lawyer.
Sure does.
You kind of understand it from the whole, from both sides, really,
Yep.
So kind of like fair and unbiased reporting, if you will. Kind of like seeing the story from all different,
100%.
Yeah.
And it's stem to stern.
Yeah.
You know how to evaluate the case on both sides, which I think makes you a better lawyer.
What's one of the more interesting or exciting cases or memorable cases that you've had over the years? Either side, I know.
Yeah.
Some good ones, I'm sure.
Not sure if this is appropriate for our audience. So I was taken, as a defense attorney, an injured worker male, his deposition, and he was Spanish speaking, so we had the interpreter there, and the gentleman's wife was there. And nice people, and I knew the other attorney really well, nice guy. And he had a very common Hispanic last name. So he had a foot injury. So I got a claim for a urologist. So before the deposition, I asked the attorney, I said, did you file this on the wrong gentleman?
Yeah.
Very common Hispanic last name. I said, you guys got a foot injury, but he's asking for a urologist. I said,
Seems like something's wrong there.
You're right. Let me go. My staff screwed up. He went and talked with his client, came back out. He goes, he's all yours. I'm like, really? Okay. Long story short, taking his deposition, he didn't have health insurance. He was under his wife's health insurance. So during the course of the deposition, through my questioning, it came out that he had cheated on his wife and he had caught an STD and couldn't get medication for it because he had no health insurance. It was under his wife. So he figured, hey, let's try to get work comp to pay for it. Case settled for $250 about 20 minutes into the deposition.
Oh my God, that's a good one.
True story.
So that is an injury, but not work related.
Exactly.
Interesting.
The foot was the compensable injury, not the urologist. Yeah. So never forget that one in all my years of practice.
That's a good story.
Pretty good stuff.
And so now employers who are out there, because we have a pretty decent size of employer practice, and I want to make sure we cover that from them. What do they need to know when someone, like, any advice on like how to accept a report of an injury, any do's and don'ts? I mean, let's tap into that defense lawyer background that you have as well.
So employers are usually penny wise, dollar foolish. if they have comp insurance, they
Yeah.
pay for it, use
Right.
it. And they're always afraid to report the injury.
Businesses are so afraid to report.
So afraid, but it bites them in the end because late reporting, I file a petition, insurance companies like, it's never reported, let's deny it. And then 6 months down the road, they're paying a ton of attorney's fees to me for securing compensability when if they had just picked up the claim from the beginning.
So in the cost benefit analysis of let's not report the claim, they are actually going to end up spending more money because they have to pay. They have to like tender their own defense or potentially exposed to pay for the whole injury, right?
No, they would have insurance.
Okay.
But insurance wouldn't know about the claim, so they deny it. Then we'd have
Okay.
a lot of litigation costs.
Got it.
Associated before it comes to light.
Oh,
Oh my
I see.
gosh, it was.
So, and so are you saying like likely any increase to the policy that could result from the reporting is going to be minimal as compared to like the thousands of dollars they're going to spend in fees to secure the
100%.
coverage? Yeah,
100%.
That's interesting. I always find that people have a knee-jerk response that can be very negative to any kind of workplace reporting. So I always tell my employers, somebody has something to tell you, the best workplaces allow for feedback, right?
Sure.
So the first thing out of your mouth should be, thank you so much for telling me. Doesn't mean you agree. Doesn't mean, that you're admitting you've done something wrong. Just thanking the employee. Let me figure out what happened. What about documentation? How important is that?
Extremely.
Yeah.
In this day and age, everybody texts. Bosses text employees. Texting or emailing would be the best way to report the injury because it's in writing. I have 2 cases right now that have been denied based upon reporting. Reporting is the weakest defense that you could have.
Right.
But both my clients, totally separate cases, both have text messages on the day of the accident. So we'll present that to them and they'll have nowhere to go.
So from the employer's perspective, will the insurance company do the investigating or should they secure who the witnesses are, what they saw, what happened? And, should they drop a net and to kind of figure out like what happened? Should they put on their detective hat or kind of leave that up to the...
Leave it to the insurance company.
Okay.
The insurance companies have, as soon as you report an injury, they have what's called a 3-point contact. They will contact the employer, they will contact witnesses, they will contact the injured worker.
Got it.
And get a basis.
They're going to do that. They're going to do their
That's
job.
what you pay for.
Yeah. So what about from health benefit standpoint? Like if an employee's out on workers' comp, is there anything in the comp statute that requires that the employer continue to pay their health benefits?
Yeah, they should pending their employment.
Okay.
There may become a time, the guy's out for 2 years
Yeah.
and he's no longer employed.
Sure.
There's a termination of the health insurance benefits, but then on my end, I get the insurance company to increase the payments to the injured worker to compensate for the differential.
Got it. So the worker gets like a set wage amount, and then that can go up or down depending on whether the benefits are denied. Wow, look, got a lot of good information here.
And fringes too, like if they provide housing,
Yeah.
if they provide a car, all those things factor into his wage rate or her wage rate, which could increase or decrease. Let's say they stop giving her the car allowance.
Yep.
That factors into the wage rate.
So in a common workplace injury, sometimes nobody's at fault, right? It's just things happen, right?
Sure.
You're cutting a roll and you cut yourself with a knife and no one's did it to you, it was an accident. But sometimes it's more than an accident.
Sure.
So anything we want to tell employees out there about that when it's...
You can't have another avenue of recovery. Work comp is your exclusive remedy. The only, meaning even if your employer didn't cover the manhole cover, knew you were walking down, no lights, you fell.
Right.
The only exception to the exclusivity of work comp statute would be under a couple of lines of cases that say you would have to show to go civil for more damages.
Yep.
You'd have to show the employer intended to hurt you.
Okay.
And that's a pretty high standard. Now, there's 2 cases.
It's like a
out there.
willfulness standard, almost an intentional standard.
Yep.
Okay, that's a high
one
burden.
case dealt with horrific facts. I won't go into it in detail, but gentleman was pinned against a wall by a forklift. So you can imagine the internal injuries that the injured worker. They prolonged medical treatment for like 6 weeks for the guy, and he developed fistula. I mean, really bad stuff. The appellate court found that it rose to the level of an intentional tort to circumvent the exclusivity of the work comp statute and let them proceed in circuit court.
Got it. Okay. So if someone's like, say in a car accident and they're driving on an errand for their boss, so it's work related, and say a drunk driver hits them, they have their comp claim, right? But then they may also have a claim against that driver as well, right?
100%.
Yeah.
Absolutely.
Okay. All right.
The cases will run concurrent. I have a few of those cases now, and there'll be a work comp lien on the third party recovery. And that in and of itself is a whole formula, because how do you base to make it easy, if he settles the case on the third party side for $1 million,
right,
they'll argue, it was worth $10 million,
right? So you got to set off,
so you only get 10% of the work comp lien, and of course the other side will say it was only worth $1 million, He got $1 million, so we should get 100% of our lien. Get experts
We see that
involved.
sometimes with Social Security disability too.
Sure.
It's a Medicare and Medicaid as well. Yeah. Interesting. So I want to give you an opportunity to talk about why people out there who are injured should call you as opposed to another lawyer. So what's your elevator pitch? What's why you?
My freebie. No, I love what I do. I really do. I love
It shows too. I can tell you're very passionate about it.
I love it. Being 53 years old, it's a whole new world insofar as the technology and the media, and it really pushes me outside my comfort zone. I'm not known to be loving change, but it's cool. Having somebody review your website or Google reviews to determine whether or not they'd call you is just mind-blowing. But I had a call literally 3 hours ago.
Yeah.
And the gentleman's with an attorney. He's not too happy with his current attorney and said, all I did was Google, can I hire a new work comp lawyer? And you're the first one that came up, and I read your Google reviews, and I want to go with you. So that's really cool. And the fact that I've done both sides really brings a breadth of experience. I know how the insurance companies evaluate claims, what they look for, what they sniff for, and I know the lawyers too. So they know.
And you're local in Jupiter. So
I'm local in Jupiter.
You're right here.
I'm right here. And after COVID, I handle cases statewide because it's all Zoom.
Amazing.
It's pretty cool. But yeah, no, I really enjoy what I'm doing. I enjoy my clients. I appreciate that they appreciate me, which is on the defense side, it was very much of a thankless job.
Right.
On the injured worker side.
Because no one's thanking you, hey, for defending the claim sometimes.
100%.
Yeah.
And I get clients who I'll ask, do you want to do X, Y, Z, 1, 2, 3? And they say, what I never heard on the defense side, I trust you. Whatever you think, I trust you. And that's really something I cherish.
That's amazing.
Yeah. Yeah, no, it's been a great tour.
Thank you so much for tuning in to the Cathleen Scott podcast. We hope this was fun and informative. We'll catch you on the next one. You can find us online at scottlawteam.com or floridalaborlawyer.com. Thank you for joining.